Good morning all. BDA have kindly invited me here today to talk about the General Data Protection Regulation, or the GDPR for short, which comes into law on the 25th of May this year, as my fairly boring stock photo shows, but it was impossible to find anything more interesting. It's quite a wide area, so I'm going to focus particularly on its impact on marketing. Just a health warning, it is data protection law, so it is quite dry. I try to make it as interesting as possible, but it's kind of an impossible task. No, I can do some photos of my 2-year-old daughter, if that helps, but there you go. A bit about myself to start off with. This is me probably about 4 years ago now, before I had children and any grey hairs. I think I was going for serious and approachable, but I'm not sure if I achieved it. I've also gone gluten-free since then, so I like to think I've sort of thinned that a little bit over time. My name is Chris Buck. I'm Associate Partner at Franklin Solicitors. We have offices in Milton Keynes and Northampton, and we've historically done some work with BDA, hence I'm asking for me to come along here today. I've been with the firm since 2005, and I'm a commercial lawyer advising on, amongst other things, data protection. And I apparently have about 15 years left in my job before I'm replaced by a computer. I'm happy to take any questions that arise during the talk, or alternatively, any questions at the end. The GDPR, as I said, comes into effect on the 25th of May this year. It takes the form of what we call an EU regulation. This means that it has direct effect in the UK without the need for any further laws to be passed by the UK government. Once it comes into effect, it will repeal the current Data Protection Directive, and it will override the Data Protection Act 1998. It therefore represents the biggest change to data protection law in over 20 years, which is why us lawyers are getting all quite excited about it. Probably in all honesty because it's given us quite a bit of work, and that means lots of money, which makes us happy. It applies regardless of Brexit. The Brexit vote was surprising, and it did cause confusion as to the future applicability of the GDPR to organisations in the UK. However, the Information Commissioner's Office has now made it clear that it will apply and that UK organisations need to get prepared to comply with it. Post-Brexit, it's all a bit uncertain. The GDPR will still be the law until the government decides to do anything else. It's probably going to be the case that they'll adopt a national data protection regime, which is very similar to it when we leave the EU, whenever that's going to be. Like the current law, the GDPR covers the processing of personal data. Processing of personal data is very broadly defined as carrying out any operation or set of operations on the data. I've listed some examples on the screen there, but in effect, any activity involving personal data is going to fall within the scope of the GDPR. The use of personal data for marketing purposes certainly will do. So what do I mean by marketing? When I talk about marketing, I largely mean direct marketing to individual customers. Direct marketing, in terms of its legal definition, consists of any advertising or marketing, whether it's trying to sell a product, a service, or just to promote an organisation and its ethos that is directed to particular individuals or companies. The GDPR defines personal data as, it's quite a long definition, any information relating to an identified or identifiable natural person who's called the data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, which would include email addresses, IP addresses, cookies, etc., or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. The new law sets out 6 data protection principles that all organisations must adhere to whenever processing any personal data. The key principle in terms of marketing is that personal data should be processed lawfully, fairly, and in a transparent manner. But what does that mean? Well, personal data will only be lawfully processed if it is processed under one of the specific grounds named in Article 6 of the GDPR. The key ground in terms of marketing will be that the data subject has given their consent to the processing of their personal data. And it's this concept of consent which is going to be key to marketing. In addition to the GDPR, we have the Privacy and Electronic Communications Directive, which requires that data subjects give their consent for any unsolicited electronic direct marketing, which would include by email, text, or an automated call. That is going to be replaced by an EU privacy regulation, which, like the GDPR, because it's a new European regulation, will have direct effect in the UK, and that is also planned for the 25th of May this year. Under the GDPR, there are new consent requirements, which I'm going to go into, and there's also a need to be transparent, and again, I'm going to go into what that actually means. So, the new consent requirements are a significant shift. Under the GDPR, consent must be freely given, specific, informed and unambiguous, given by a statement or a clear affirmative action, and that's the key concept and it's a key shift, as easy to withdraw as it is to give, and kept separate and distinct from other terms and conditions. Examples of affirmative actions would include ticking a box when visiting a website, for example, and also choosing technical settings within a website for an online service. It's this requirement for an affirmative action that means things like silence, pre-tick boxes, inactivity, or just a failure to respond and opt out will not constitute valid consent anymore. So automatically adding customers to a marketing database, for example, and then waiting for them to opt out is no longer going to be lawful. One of the main objectives of the GDPR is to give the control of personal data back to the consumer, and this is one of the main ways that it does that. If you're anything like me, it's not uncommon for your personal email account to look like that after a morning. Sports Direct are usually one of the ones that are on there, but it's not on that example. They're constantly emailing me about Kangol hoodies, which are on sale. So essentially what it is marketing emails which you are receiving because you failed to opt out. In theory, if everyone complies with it, the GDPR should put an end to this. The need for consent to be as easy to withdraw as it is to give means that if the granting of consent is made easy for users, for example by ticking a box on a website, the withdrawal of the consent will need to be made equally as easy. In addition, controllers must be able to demonstrate consent, so that points to record keeping. So this may require not only review of your consent mechanisms, but also the introduction of new record keeping procedures. If, for example, consent is provided online when data is submitted, this should be set up so that a record is kept of the data which is submitted, and a timestamp to a link of your relevant version of your privacy policy which is enforced as at that time. The new law also imposes enhanced transparency obligations on controllers. Under the GDPR, controllers must provide data subject with information notices or privacy policies by another name, which contain prescribed information about the processing of the data subject's personal data. Article 13 details all of the information which must appear within that privacy policy. I've listed some of them over 2 slides. I don't propose to read them all out, but I've set them out to highlight just what needs to go in there. The information includes the purposes of the processing, who the data might be shared with, and the rights of data subjects. The ability to withdraw consent to any marketing-related data use must also be explicitly explained to data subjects in a separate section. Helpfully, the law says that this information must then be provided in a concise, transparent and easily accessible way using clear and plain language. So clearly there's a bit of a conflict between all the information you need to provide and that requirement, which represents a bit of a drafting challenge for us lawyers who aren't necessarily used to talking in concise, transparent and easily accessible language. The GDPR allows organisations to rely on existing consents, which is useful, but only if that consent satisfies the requirements of the GDPR. If those requirements are not satisfied, then new compliant consent will need to be obtained. It is very unlikely, in all honesty, that any existing consents are going to be compliant with the GDPR requirements around opting in and also the vast amount of information that you need to give to data subjects in a privacy policy. As such, it is very likely that you're going to have to obtain new compliant consents in order to market to people. This will involve contacting your current database of customers who you market to and inviting them to opt in to continued marketing by accepting a new GDPR compliant privacy policy. This is what we as a firm are doing at Franklin's. As highlighted on the screen, we have historically sought consent to market within our terms of business, which we send out to our clients. As is quite common and as is perfectly lawful at the moment, this is dealt with marketing consent by way of an opt-out procedure. As such, all of our consents which we have at the moment are, and helpfully, not GDPR compliant. So like many, we're having to build up our marketing database again from scratch. So we're emailing clients at the moment, where we can lawfully do so, to invite them to opt in for marketing and presenting them with a GDPR compliant privacy policy. The hope is that pre-25th of May we'll get as many as possible to do that, but inevitably there's going to be some people who won't, and we're going to lose some of our marketing database, and that's going to be an inevitable consequence for many, unfortunately. We've also amended our terms of business to make them GDPR compliant from an opt-in perspective, as highlighted on screen. So we now seek express opt-in consent to our privacy policy and also to marketing. Whilst this might all at first appear to be a bit of a burden, it could potentially be used as a positive opportunity to keep your data set neatly segmented so that you only contact customers about the information that they actually might be interested in. This is the approach that Twitter have taken, for example, as highlighted on screen. This might be something to consider, as then you're then more likely to have a greater prospect of having engaged and interested readers. Another strategy is to invite visitors to your website to opt in via a pop-up procedure on the website, which is then linked to your privacy policy, which should obviously be GDPR compliant. Others have taken an entirely different stance. Pub chain JD Wetherspoon, where we've all probably frequented one time or another, took the unprecedented step of deleting their entire email marketing database, which was more than 650,000 email addresses. As shown on screen, in a letter from their CEO, John Huston, they informed customers that all of their customer emails will be securely deleted, and have instead invited their customers to check their website, Facebook page, etc. for news on the organisation. The GDPR also has an impact on data processors. In a significant departure from the current law, it now applies to both data processors as well as data controllers. A data controller determines the purposes and means of the processing of personal data. A data processor, in contrast, processes the personal data on behalf of the data controller. So if, for example, you collect personal data from your customers and pass it on to a third party like BDA to assist with a marketing campaign, your organisation will be the data controller and BDA will be the data processor. The GDPR imposes further requirements on that controller-processor relationship. So when appointing a data processor, for example, controllers must now ensure that they have a written data processing agreement in place, which meets the detailed requirements set out in Article 28 of the GDPR. The contract must set out a number of matters and must also contain a prescribed list of clauses. I've again set out on screen what needs to be provided for, but again I don't propose to read it out because it's all quite lengthy, to be honest. It includes the purposes of the processing and ensuring that those who have access to the data are bound by confidentiality undertakings. Organisations will therefore need to have a controller-processor contract in place which they can deploy and present to processors, and also processors like BDA, for example, need to expect to be asked to enter into such a contract. In turn, processors should really be asking for contractual assurances around a controller's compliance with GDPR in respect of the personal data which they're going to receive and process on that controller's behalf. The GDPR also builds on the current law by enhancing existing data subject rights and adding a number of new data subject rights. So are there any fans of 80s synth pop in the room who are able to name the group?
Erasure.
Correct, Erasure. Right, you'll see what I've done in a minute. No, I can do. So, new data subject rights introduced by the GDPR include the right to erasure of personal data. See, I said I'd make it interesting. Also known as the right to be forgotten. A data subject can request erasure of their personal data in a number of specific circumstances, including where they withdraw consent to processing and where they object to the processing of their data for direct marketing purposes. If you receive a request for erasure, the controller must respond without undue delay, and in any event within 1 month, and use reasonable efforts to notify others with whom it has shared that data to erase it, such as processors. So it follows from this that you're going to need systems in place to ensure that you can respond to such requests quickly and in time. This is probably the most important bit in terms of enforcement and sanctions. Supervisory authorities retain broad investigative powers. For example, they can turn up and conduct on-site audits without notice, issue public reprimands and warnings and remediation orders. In the UK, the supervisory authority is called the Information Commissioner's Office. They can also impose fines. Their powers may be exercised against both data controllers and data processors. One of the key changes under the GDPR is the significant increase to the level of the fines. Breach of the conditions around consent, for example, can lead to fines of the higher of up to 20 million euros or 4% of total worldwide turnover. Obviously, that's a worst-case scenario, but the guidance issued by the Information Commissioner's Office is that the fines are designed to be punitive and to enforce the GDPR, so they are going to be quite high. This is certainly significantly more punitive than the maximum of £500,000 under the existing law. There's also the possibility of claims for damages by data subjects themselves against organisations directly. It is significantly easier for individuals to bring private claims against both controllers and processors under the GDPR. They can claim compensation for distress and hurt feelings even where no financial loss has been suffered, and that is now on a statutory footing. So with the rise of the consumer generation and all the information about this is on the internet, that's likely to affect some organisations. The GDPR is very wide, and it is far too much to cover in a 15 or 20-minute talk or so. I've listed some of the further points which are covered on the slide. These include how it impacts on data held on employees, which is a whole other area in itself and which will impact all organisations because we all have employees, and also the appointment of data protection officers. So my advice is to do your own research on it. The website of the Information Commissioner's Office is very helpful and contains quite a few guides on it. And where necessary, take legal advice on it. Thank you for listening, and I hope you find it informative.
Hello, yes. Thank you very much, Chris. Very interesting. A lot to take in. And yeah, to scare everyone a little bit more. It's 127 days until the 25th of May, so it really isn't very far off. But are there any questions in the room? There is one at the back. There's two. Oh, goodness. Right, we'll start right at the back. Stephen.
This is why I start charging.
Hi, Chris. I work for a wholesaler. The clarity I want to check in is we rely on a field sales team calling on those businesses, and we've mobile enabled them with Salesforce, and they collect a lot of customer information on that. Can we use Salesforce to collect consent because that consent is taken by the field sales manager and not by the customer?
You can do, providing the consent procedure is an opt-in one. So the customer is given an affirmative action to opt in to your privacy policy.
Okay. So if we hand the device over, and they tick a box and enter their name, as long as we keep a clear record and evidence,
provided
that works.
that box isn't pre-ticked and they don't have to untick it, they have to take some affirmative action, then that's fine.
So how does that work with the ease of withdrawal? Is it just the reverse of they speak to their account manager and then they can ask that to be taken off?
If they have an account with you which they can log into, it can, through that procedure, if there's an untick to withdraw procedure, it's equally as easy to give consent as to withdraw it, so that would work.
Okay, thank you very much.
Chris.
Yeah. My question is actually for BDA. With GDPR coming in, you're really going to be affected in the way that if you do any target marketing, days gone by, you used to buy databases from Dun & Bradstreet and things like that, go after a certain segment of market. How are you going to comply with GDPR and still implement a growth target market strategy?
They're going to take my advice on it.
Yeah, we're working with Franklin's.
Sorry.
In all seriousness, yeah, we're working with a good legal advisor to make sure that we do comply. We've been talking to Chris since last year on this, and we've been doing our own reading on the subject, and it is a massive subject, and it's a lot for us all to be concerned about, but it's how we can turn that concern into an opportunity for us and make sure that we are getting the right messages to the right people. We really do want to get them. So, yes.
Yeah, I think the days of buying marketing databases have begun essentially, so it does need a bit more focused thinking.
Absolutely, but we're very aware of it, and we know the work that we're doing already. We're looking at the implications for GDPR already in the build that we're doing of websites and data collection, etc., etc. So, yeah. I don't know whether that answers your question though, Chris.
And it's a difficult one because I
It
can't
is,
see a
yeah.
solution myself either. I don't know how you can target and try and put your products or your services to a new potential customer if you're not allowed to know who that customer is. I kind of understand how can you sell your solutions to someone?
It's about making your content and what you are actually wanting to say worth wanting to have. Yes. So create really good content, be exciting, be something that they want to subscribe to, they want to opt into, and you're going to get your audience. If you're going to send out dry, dull, Sports Direct, Kangol, hoodie stuff, you're going to lose people.
Which
So
is
how do we turn
probably
that round?
Probably why Weatherspoons took the stance they did, you know.
Yeah. That was the only way I could see
You
it,
come to
right?
us.
They were coming to you.
Yeah.
I wanna ask any more questions.
Yes, goodness. Shall I start here and then I'll go back there? There we go.
Hi, Chris. I think mine actually follows on from the question at the back. We've got a similar issue, but we don't have field sales. We just have people on the end of telephone, just when they're speaking to someone who's called in, asking if they'd like to be kept up to date with sort of news, events, and offers. And then if they say yes, we tick the box on the contact record at the moment. What's your thoughts on that
is
process?
sufficient. So if you go back to the definition of consent, so I'll go back into my notes. So it needs to be given by a statement or a clear affirmative action.
Yeah.
A statement includes an oral statement, so that would be fine. But obviously, you need to be able to evidence that consent. So you need to keep a record of that same look. Yeah. And you give the usual warning before that recording is made.
Quick question, sorry. In regards to GDPR, I've heard rumours that GDPR doesn't affect direct print marketing. Is that true, or is that a false rumour?
Can you explain to me, as a lawyer, what direct print marketing is?
So if I was to send a mailing out to a database that's been obtained and we've got, does GDPR affect that? Is that going to be against the law because obviously they haven't opted in potentially, or is it purely down the digital route?
If you're not doing it to a named individual who's identifiable from the data you're using, it wouldn't apply to it. So the direct marketing I'm talking about largely is email based. So if from an email address you can identify that person, it's personal data, and you're using that personal data to market to them. So it comes down to whether you're using personal data to market. So if you're doing a mail shot in the post, then it's unlikely to apply, I would say.
Thank you.
Are there any more for any more?
Sorry, so just to pick up on that.
Do you want to?
Yeah, sorry. So if you don't personalise something, basically, you can post.
Yeah.
So it's just losing the personalisation. Okay.
So to clarify, that's just you can't use their first and last name on it.
Yeah.
So you could send it to BDA,
Yeah.
but you couldn't send it to David Knowles at BDA.
Yeah.
Right, okay.
And it's the same with email. So if an info at BDA, that would be fine. But if it's david.knowles at BDA,
Right, okay.
then you're struggling.
Right. Lot to think about. There's another question at the back.
So I'll try and make this one very simple. About 10 years ago, I worked for Experian, and we sold consumer data. So it's kind of related to that. Don't want to go back there. That's a different story. But if, as in Experian cases, they would collect consent for third party, and we buy a mailing list and challenge Experian to give evidence that they have third party consent, can we still therefore personalise direct mail communications?
The problem with that is, within the consent to pass the data to third parties, under the GDPR, you now have to name all the third parties that you're going to pass to.
Okay.
So it's going to be very difficult to name every possible third party you're going to be able to pass it to. So I doubt you're going to have that assurance that they're going to be GDPR compliant.
Which explains your comment about databases perhaps being
Yeah, they're
having
gone.
their time.
They're gone
So-
essentially.
Okay, thank you.
One final thing. What if you don't know who in the future you're going to pass that data to?
then yeah, you can't specify it in the policy. It's not going to be, the consent you obtain to pass a third party isn't going to be compliant, so you can't lawfully pass that to.
So you can't put a catch-all type statement in?
No, and that's how lawyers have drafted privacy policies up to now, but it's not going to be possible moving forward.
Ooh. Okay. Any more for any more?
We've got Europe to thank.
Okay. Don't think we've got any more questions, so I think it's lunchtime.